Yes, Mr Mansfield.
Please you, my lords, in this matter I appear together with my learned friend Mr Jackson for the appellant. My learned friend Mr Laddie QC and Mr Smith appear for the respondent to the appeal. And my lords, this appeal arises out of a 3-day summary judgment and strikeout application heard before Mr Metzer QC, sitting as a Deputy High Court Judge, in March of last year. As your lordships, I hope, will have seen the scene set in the early stages of our skeleton argument. My client was the executive chairman and CEO of the AA, company well known, I'm sure, to everyone in the court. He has a claim for wrongful dismissal arising out of a summary termination on the 1st of August of 2017. Liability issues in relation to that claim for wrongful dismissal are going to go to trial. There's no dispute about that. It wasn't the subject of the strikeout application. And that will be a substantial trial, as even on the defendant's case, as to the basis of assessment of damages, the sum is going to be in the region of some 750,000 if he succeeds on a liability basis. So there's no doubt that this is a case that will need to go to trial. And more importantly, for the purposes of the summary judgment and strikeout application, and for the purpose, therefore, of this appeal against that, the assumption for consideration is that my client will succeed at trial, i.e. that he will establish that he was wrongfully dismissed, and damages will fall to be assessed on the basis that he was a wrongfully dismissed employee. That wasn't in issue at the application below. What was in issue were a number of challenges to the basis of loss that was claimed by my client. And below, those broke down into what were described by Mr Goldring, the solicitor for the AA, in his statement in support of strikeout and summary judgment, as 4 applications. So you'll see them referred to as the first application and so on. In fact, only 2 of them are live now in appeal, and that's for this reason. So if I take them in order, there's the first application related to my client's claim for damages in relation to a 12-month notice period.
Yes.
That he says if he'd been given notice, he would have had the opportunity to have earned bonus, and he would have earned various ancillary benefits, pension and life insurance and so on. He claims damages for that. The defendant applied to strike out that application on the basis it was bad as a matter of law, because he was only entitled to damages assessed on the basis as if a pylon clause had been operated. That was what was called the first application. The judge struck out my head of claim on that regard, and I appeal against that.
Yes.
The second and third applications both concerned different components of what you may have seen called the MVP shares claim, or the Mackenzie shares claim. 2 slightly different applications in relation to that. The only one we're concerned with here is what's called the second application, and that relates, that summary judgment application was advanced by the AA on the basis that the forfeited shares we're arguing about, that my client lost when he was a bad leaver, never hit their target price to trigger an entitlement, and we have no reasonable prospect of showing on the facts that they would have done but for the breach of contract. And the judge granted summary judgment against me, against my client on that, and I appeal against that. The second, there was a more detailed point about MVP shares which the parties agreed between them during the course of the application. That was called the third application, but it falls away because we agreed that it wasn't live. And then there was a fourth application relating to an alternative claim that my client brought for personal injury, effectively a stress at work claim, which the judge gave summary judgment for. And he gave summary judgment on the basis not that my client hasn't sustained an injury and without resolving any causation issues, but the point taken against us and on which we lost was that we had no prospect of showing foreseeability of harm to trigger breach of a duty of care on the part of the AA.
Well, no duty. So duty admitted, but no prospect of showing breach because no foreseeability.
Indeed, my lord, yes. And we lost on that, and we don't appeal. bad assessment of that particular factual issue. So the live issues are in relation to the basis of approach to damages for a wrongful summary dismissal, as to the approach that's taken to looking on the first application, what's called the ancillary benefits claim. I use that term to mean both bonus and other benefits. That's the first application, and the second application relates to the judge's finding that we had no prospect of showing that the shares could have reached the relevant target. So that's the scope of the issues now live before the court, my lords. If I can deal with them in turn, and if I can start on the first application and look first of all at how the judge dealt with the matter. The judgment you'll find in your core bundle. And if you'll forgive me, my lord, mine's exploded in the course of transit over the court. Note to self, always check that before the judges come in.
I'm glad some things have never changed.
My lords, forgive me. So in core 68 is the beginning of the judgment. And I deal, for your reference, at paragraphs 8 through to 10 as to the approach that the judge took. He starts with this application at C74. Sorry, C73. You'll see just above paragraph 20, the heading, the first application. And he records there that the first application relates only to benefit and bonus in the 12-month notice period, and that A's, that's the AA, the applicants, accept the claim will proceed to trial on the liability, and the claim for damages must proceed in relation to the claim for loss of salary for that period. He states the general proposition in relation to the purpose of damages for breach of contract to put the respondent, that's the employee in this case, in the position he would have been in had the contract been lawfully performed. And that requires a comparison between an actual position and a counterfactual or but-for position, as if the contract had been performed. But in this case, the judge records over the page at paragraph 22 that the AA maintained that there's a presumed basis, on the presumed basis that the claim that he was wrongfully dismissed is held, the court would be obliged to assess damages on the assumption that the service agreement would have been lawfully terminated in the manner least burdensome to the AA, relying on Laverack and Woods of Colchester, which is a case that I'll turn to in a moment. And the judge correctly records at 23 that the contract provides a number of different mechanisms by which it might be terminated. And the services agreement is in the bundle, my lords. We can turn to it if it would assist any of your questions.
Where is it?
It's in C 150.
Tab 11.
Oh, yes.
Quite possibly, my lord. I don't have any tabs, I'm afraid.
Nor do I.
But it is tab 11 indeed, looking at the index. So, my lord, now we're at the contract. Rather than taking the judge's summary of it, I'll take you to the relevant provisions, if I may. After a fairly lengthy definitions and interpretation section, one gets to appointment at term at clause 2, page C154. 2.1, the company shall employ the executive, and the executive shall serve the company as executive chairman on the terms set out in the agreement. 2.3, the executive's employment shall continue subject to the provisions of this agreement until terminated by either party giving to the other not less than 12 months written notice. And then you'll see at 11, further provisions in relation to termination. That's page C162. The company shall at all times be entitled to terminate this agreement pursuant to clause 2.3, 11.2 or 11.3. 2.3 we've just looked at, that's 12 months written notice. 11.2 is obviously the immediately following subparagraph. The company may at its sole and absolute discretion terminate the executive's employment forthwith at any time and undertake to pay the executive within 14 days.
I mean, given that this was drafted by Clifford Chance, it cannot possibly be wrong, but I just don't understand the syntax of lines 2 and 3. What does it mean? Terminate the executive's employment forthwith at any time and undertaking to pay the executive within 14 days pay to the executive.
Well, I think the second pay to the executive is ATO's verbiage.
Surely not. It must be very expensive.
Well, it is hard to believe, my lord, I know, but that's the only sense that one can make, I think, of that.
Well, I mean, you could actually say the undertaking bit is irrelevant. The really important bit is the payment within 14 days. I mean, I think you're both agreed that the gist of what it says is, under this pylon scheme, they can terminate forthwith and pay within 14 days a year's salary.
Yes.
Full stop.
Yes. And I don't, Mr. Laddie will correct me if I'm wrong, I don't remember any debate about this at the hearing before the judge about...
Okay. Well, it may be unnecessary in that case to understand the beautiful complexities of Clifford Chance's drafting, if we're agreed about what it means.
Indeed, my lord. And so, leaving aside that question of the repetition of pay to the executive, one sees a sum equal to basic salary in lieu of any required period of notice under clause 2.3 or an unexpired period thereof, and together with accrued holiday entitlement. And then at 11.3, notwithstanding the provisions of clauses 11.1 and 11.2, the company shall be entitled, by notifying the executive in writing, to terminate this agreement and the executive's employment forthwith, without any payment, by way of compensation, damages, payment in lieu of notice or otherwise, if the executive shall do one or more of a number of things, A to H, and the first of those, A, is commit an act of gross misconduct. That's the only one we're concerned with. So one sees, my lords, that
is E irrelevant? Somebody has underlined it, not me. Act in any way which may in the...
It goes to your Boston, or goes to the Boston shipping point, doesn't it? Because there was, I don't know whether it's still live, the case that he'd misbehaved in relation to some neighbour, and got into an argy-bargy.
Yes, my lord, you're quite right about that. It does go to that, and that's when I gave my headline outline of what's going to trial. I omitted that. Your lordship's right. That issue, which goes to reclawing earlier paid bonuses, is also a live issue that will go to trial.
But we're not concerned with, in answer to my lord's question, we're not concerned with E for today.
No, I don't believe so. Because the dismissal was put on the footing of an act of gross misconduct. So, my lords...
And your case on 11.2 is it that if they don't dismiss using the pylon clause, then that's gone as an alternative, and they don't pay within 14 days, that's it. Then if the dismissal purportedly under 11.3a is found to be wrongful, then damages are at large.
Well, I don't put it quite that high, my lord, I put it like this. There are, as we've seen, there are three alternative means of termination that we just looked at. Notice, if I summarise them in this way, notice, pylon, and a misconduct summary termination. What happened in fact in this case is that the company chose to exercise 11.3 to a conduct summary termination.
Yes.
But it didn't have the right to do so. That's the assumed fact.
Yes.
So the question then is, it having breached its obligation by doing something it wasn't entitled to, what is the approach that the court takes to what would have happened in the alternative? We say that requires a factual assessment of what the employer would have done at the date of termination had it realised that it wasn't able to summarily terminate. And the lawful options open to it at that stage were either notice or pylon. The AA's case, Mr Laddie's case, is that...
or neither, and continued employment for more than 12 months. What's puzzling me at the moment is how your case on this appeal is consistent with your ancillary benefits claim being limited to a period of 12 months, which is based on clause 2.3 as the counterfactual, not based on a general counterfactual of what these defendants would have done.
Well, I see that, my lord, and I see that point taken by Mr Laddie.
What's the answer?
Well, the answer to it is this, that in this court, although I would want to preserve the position for the Supreme Court, I feel constrained to accept that part of the assessment of damages exercise is that there would have been a lawful termination rather than the contract would have continued sine die without limit. And the reason I say that is I think I'm constrained by the House of Lords decision in Johnson and Unisys, which deals with the interplay between contractual damages and unfair dismissal. So, whilst reserving my position for another court, I'm, as I hope you'll understand, my lord, not saying that one can ignore that decision in Johnson and Unisys. So, but that still leaves a choice for the employer, or rather a matter for the court to assess as to, assuming that the employer is to be taken to be choosing to terminate, what is the counterfactual? Would it have made the pylon payment, or would it have terminated on notice? And we say that that's a factual question that needs to be determined at trial as to which it would have done. Mr Laddie says the court is constrained to proceed on the basis that the pylon would have been operated rather than notice being given. And I accept, my lord, that that leads to, well, I say I accepted it. I say that that does lead, the constraint that I placed on myself with recognising Johnson, I say does lead to an unjust, an illogical outcome. But that's a matter, I'm afraid, that I shall have in due course, if I need to, raise with the Supreme Court. And the reason I say that is this, and we see it in, Mr Laddie makes this hypothetical in a footnote to his skeleton argument. Assume a blameless employee who is wrongly accused of theft, let's keep it simple, for which there is no basis, and the employer decides to dismiss him for gross misconduct. Because he did not commit an act of theft, there is no gross misconduct, and the employer is not entitled to do that. Well, one would think, if one was starting with a blank sheet of paper, that the appropriate basis to assess damages would be on the basis that that employee would not have been dismissed, because there is no grounds to do so. But I recognise that it's been established at the highest level that one makes an assumption that the employment would have terminated lawfully, even though the employer's actual reason for doing so doesn't exist. And I accept, I think, Mr. Laddie's point that to argue to the contrary in this court is an insuperable obstacle because of Johnson. But if one was starting from first principles, that doesn't really make sense, and it doesn't really compensate the employee for the wrong that has been done to them. In this case, therefore, I say...
Depends how you formulate the wrong. He's been unlawfully deprived of his continuing employment.
Yes, indeed.
Then you look at the security of his continuing employment, if you want to know what the real wrong is.
My Lord, yes, but I say that ought to be a factual assessment rather than the application of a hard and fast rule, and second, the application of a rule that is most favourable to the defendant, i.e. to the contract breaker, not to the innocent party. But in this case, I say, well, I don't need to succeed in this court, I don't need to take on that Johnson principle, because even if one accepts that one is to assess damages on the basis that the employer would lawfully have terminated, the question then arises as to, well, what lawful means of termination would the employer have used? And in a case where the contract only provides for notice, one simply assesses damages on the basis that notice would have been given. But in a case where the contract offers a choice to give notice or to make a pylon payment, the court has to determine which assumption to apply, and they have very different consequences on different facts. Mr. Laddie says, well, there's a hard and fast rule about this. It's got to be the least burdensome to the employer, and that would be the application of the pylon clause. I make 2 points in the alternative. First, the authorities don't require, when looking at the choice between notice or pylon, one or the other. There is no hard and fast rule, and it should be a matter of assessment on the facts. And second...
Sorry, by which you mean there isn't any less burdensome principle at all, and it's the counterfactual.
Yes.
Is simply what would have happened.
Yes, my lord. Yes. Yeah. And I say that the cases don't dictate a different answer to that. And second, I say, even if one applies a rule that one looks in the contract for the least burdensome means of the employer terminating, that question cannot be answered simply by reading the 4 corners of the contract, and can only be assessed in the light of the facts, not just of the termination, but as they turn out over time, which will be the least burdensome to an employer in any particular situation, will depend on a whole range of circumstances. Because these different mechanisms are put into employment contracts to serve different situations as they may arise. So, my lords, when one thinks about some of the old...
I'm sorry to keep interrupting.
Not at all, my lord.
Is that an objective or a subjective question? Is it what would be least burdensome to a reasonable employer, taking into account that employer's own commercial interests, or is it what would these particular defendants have regarded as least burdensome?
Well, I say this employer acting reasonably in the circumstances it found itself in good faith and taking its own commercial interests into account. I say
Sounds pretty objective to me.
Yes.
Well, the two aren't the same. It may be possible to say that it would be reasonable or not unreasonable for an employer to act in a particular way, taking into account its own commercial interests and not cutting off its nose to spite its face. It might be a quite different factual inquiry as to what this particular employer would have done. The first may be relatively straightforward,
Yes.
The second may involve a much more complex factual inquiry, so it may make a difference.
Yes.
So which is it?
The former.
It's objective.
Yes.
Thank you.
So, my lords, that leaves us with, just to summarise where I got to in that, explaining the shape of the case. First, assuming that if the employer had been told that it couldn't dismiss for gross misconduct on the 1st of August 2017, which of the alternative methods of termination does the law say has to be applied, or does the law say it doesn't have to be one or the other, and then it's a matter of assessment? And second, even if the law says, well, in choosing between those two counterfactual alternatives, one has to look at the least burdensome, what in fact was the least burdensome option? And we say both of those questions are not matters that can be answered simply by looking at the contract, and need a detailed factual examination that by the judge, by applying a hard and fast rule of law, has precluded us from having those matters assessed at trial, and he erred in that respect.
So you say there can never be summary judgment in this type of case. It always has to go to a trial.
Well, I don't think I'd say never, my lord, but I'd say I don't think I need to say never. Cases throw up all manner of factual scenarios, some of which are clearer than others, so I wouldn't want to lay down a hard and fast rule. But I do say in this case, which was the course that would have been taken and which was the least burdensome, can't be determined as a matter, certainly not as a matter of strikeout, and nor we say as a matter of summary judgment.
Are you saying that the tribal issue as to whether, had the board been advised that Mr Mackenzie's conduct did not amount to gross misconduct, that there was a seriously tribal issue, serious possibility that the board would have said, in that case, we will keep him in post for the next 12 months?
Yes. That's exactly what I say.
And I think Mr Laddie's case on this is that on any view, he was not fit to remain in post for a day longer, whether that's, as the company say, because of his fault, gross misconduct, or as he said in his resignation letter, that he just couldn't go on, that he wasn't in a fit state to continue.
Well, my lord, first, that's not the basis of the decision below. The decision below was taken as a matter of law, as a strikeout, that it wasn't open to enter into the inquiry. Second, I accept that on my own case, Mr Mackenzie needed a period of some months' convalescence before he'd be in a position to return to work.
6?
6 months, indeed. Third, the letter upon which Mr Laddie relies has to be seen in its circumstances, to which I refer in the skeleton, and we refer to in our amendment to the reply and defence to counterclaim, that it was in circumstances where he had, after the incident that led to the dismissal, he had put forward medical evidence explaining the stress and anxiety that he was suffering at the time. The company had indicated it regarded that as a try-on, and it had been made clear to him in no uncertain terms that if he didn't resign, he was going to be dismissed. So in those circumstances, it's a matter for trial, we say, as to what, if any, weight is to be attached to it.
I don't understand what you're saying. we've got a letter sent on his behalf by reputable solicitors. Are we to ignore the terms of the letter, or say they don't count, or say they don't mean what they say, or what?
Well, it's the former. Our case on the facts is one can disregard that in the circumstances that it was written.
And a reasonable employer and or these employers in the counterfactual would have disregarded the letter.
Yes.
See?
Yes. We'd say two things. First, a reasonable employer would have disregarded it.
Why?
Well, a reasonable employer would have had taken account of the extreme circumstances in which it was written.
But that doesn't render it unreliable. One would think that all the more reason to think it wouldn't be sent unless it was reliable.
But also, we say our pleaded position is that insofar as the claimant was asking to be released from his obligations, a reasonable employer and this employer wouldn't have accepted that.
But would have left him in post, albeit convalescing at home, as chairman and chief executive of a public company.
Yes.
Rather than saying, here's your 12 months, pay in lieu of notice, goodbye and good luck.
Yes, indeed, that's our case. We say that they wouldn't have made the payments in lieu of notice, and that in any event is a factual question that should have been resolved at trial, rather than on the basis of the application of a rule of law.
So,
Can we just see the letter before action, which my lord referred to? Is it in the...
It's in the supplementary bundle, my lord, and it's at...
280, is it?
Yes.
So, just while we're on our way there, what should the reasonable employer have assumed or taken into account? The account of the incident as set out in paragraph 34 of the claim of the particulars of claim, which includes repeated pushing against Mr. Lloyd's chest.
Yes.
Or should a reasonable employer have assumed that nothing happened, or what?
No, the reasonable employers would be entitled to assume the claimant's own account of what happened. But his case, in the context of such discussions there were about the consequences of that, were one, the incident in itself was not so serious, but two, the fall that he had immediately prior to it and his health condition in any event was strong, extenuating circumstances for whatever happened at that time.
Yeah, I understand. I'm not putting to you that the wrongful dismissal claim is without foundation. It's a matter of principle. I understand that your case is that what happened was brought about by extreme stress and so forth. But what I can't get my head around is the proposition that assuming all those facts in his favour, there is a reasonable possibility that a reasonable board would have said, we terminate your contract on 12 months' notice. We understand that you're at present not fit to carry out your duties, but we expect to see you back in 6 months' time.
Well, that is our case. We say that it would have allowed for a better managed exit that would have had less of an impact on the market and on the share price than what in fact happened, or what would have happened in the pylon scenario, and that it would have allowed first the existing strategy that we say was going to bear fruit to have continued.
Well, it would have resulted. It would have had to result, wouldn't it, in the immediate appointment of a new CEO?
In the interim,
if he was, as he declared, unfit for an indefinite period of time.
yes, in the interim, That would have had
there had to be a new CEO, and we would assume in the counterfactual that that would have been Mr Breakwall, don't we?
except there's no other alternative on the evidence.
And,
Yes.
that he would have been leading the management for the period of 6 months at least,
Yes.
when your client wasn't there.
Yes. But he would have, after that convalescence, steps could have been taken to, we say would have been taken, to have managed the exit and handover in a sensible manner. The problem, part of the problem in this case, is that the way in which the departure was handled, and we say it would have made no difference if the pylon payment had been made, had an immediate negative impact on the market and on the share price and on the business. And that's a risk that any employer has to weigh up as a powerful negative to acting in that summary manner. But my lords, these are...
That can only be determined after a 10-day trial yet to occur, at which members of the board will have to give evidence as to what decision they would have taken.
Yes.
Okay, right, got that.
Whilst we've blown you off course from the resignation letters, can I just raise another point with you? And this may be completely off-beam because it isn't a point that's taken against you, but there are in fact two resignation letters. There's the one we've just been looking at, and that wasn't effective because it wasn't accepted. But there's also a letter on the following page of resignation as a director of the various AA companies. Would I be right in assuming that he would need to be a director of those companies in order to fulfill his obligations under his employment contract?
The immediate answer is, I don't know, my lord. Can I think about that?
Well, it seems you certainly can. The reason I think it's likely is that those were the companies, one I would assume, of which he was a director, and they include a PLC, and I would therefore infer, although you can come back on this, that those were the companies that he would need to be a director of in order to act as CEO and chairman. He'd certainly need to be a director of some companies, wouldn't he?
My lord, yes, may I revert on that? It's not
Yes.
a question that's arisen at any stage in the proceedings to date.
No, and you can come back on all of this. But if that's right, then before he was dismissed, he had resigned from all the directorships, which would have enabled him to perform his employment duties. And I think I'm right in saying resignation takes effect unless there's something else in the articles, simply by the giving of notice. It's not a consensual process.
I accept that.
So at the moment that he was in fact dismissed, he had, by resigning from the directorships which he would need to have, disabled himself from performing his contract of employment, which might look a little bit like a repudiatory breach. And the reason I raise this is that may have an impact on the issues in the case and the issues we have to decide in either or both of two ways. It may mean that the employers were entitled to dismiss him summarily, and there is engaged the principle that it doesn't matter if you give the wrong reasons at the time, if you have good reasons. Or it may be that it feeds into the arguments that we are being asked to address as to what was the minimum obligation or the least burdensome way of the contract being performed, which would have been acceptance of this as a repudiatory breach and not even payment in lieu of notice. Now that's rather a fast ball because it's none of that's a point that's been taken against you. But I thought I should raise it because it is something that's been in my mind, and it may be that there's an obvious answer to it. But I'd like some help with it in due course.
Indeed, my lord. And I see that question's been in your mind. The honest answer is it hasn't been in my mind, but it is now.
Yes. Well, of course, you can come back on it.
Yes. But what I say about it in any event is the same point applies to this letter as to the resignation from employment letter that it's sent with, i.e. that in the circumstances in which it's given, first, we say no weight to be attached to it. And second, that's a matter for trial. Now, your lordship's either like that point or you don't like it. But I'd say it applies in the same way to both.
Well, but we're not looking at quite the same thing. I understand when we were looking at the previous letter, we were looking at what weight would have been given by a reasonable employer to the content of the letter saying he was unable to perform his duties. Here, we're simply looking at the fact of resignation. I mean, there was no obligation, was there, to reappoint him as a director?
No, I think I have to accept that.
So if he wasn't a director of these companies, and if it be the case that he would need to have been in order to continue, why is the counterfactual that he would have continued to be employed? I mean, that's the area in which I'd welcome a little bit of further assistance. But you can have time to think about that.
Okay. My lords, can I just take a moment to rechart my course as to what was most serious?
Yes, by all means.
I had intended, in line with my skeleton, to grapple with next with some of the authorities on the principles as to what the scope of the minimum obligation or least burdensome means of performance rule is, and how it applies in this case. And then go on to my secondary argument, which is that least burdensome doesn't necessarily mean the pylon, as opposed to notice, as a general proposition, and on the facts of this particular case. But I see my Lord Justice Bean has some concerns on the factual propositions, and that's what we've been dealing with now. I'm content to reverse my batting order if it would assist your lordship. But
We've given you enough trouble, Mr Mansfield. If you want to start with the law and then go on to the facts, then that's fine.
I'm grateful, my lord. So, if I can return to the judgment, and that's in the core bundle I was at, I think, C, paragraph 23. Yes.
Yes.
On page C74. The judge then summarises some points that I make about whether or not pylon is least burdensome or not. I'll come back to that. But at the heading over the page at C75, the judge then deals at paragraphs 25 through to 31 with the authorities to which he'd been referred during the course of argument, starting with a trust case, Robinson and Robinson. And you can see the cases there that he sets out. Over the page at 32, he sets out his conclusions. Paragraph 32, the basic claim for loss of 12 months' salary at paragraph 42.1 is not an issue before me and requires determination at trial, depending on whether Mr Mackenzie establishes this as a wrongful dismissal claim. Then he records that this aspect of the case is about the bonus, opportunity to earn bonus and ancillary benefits. He says, in the course of submission, I suggested that least burdensome effectively means cheapest, and that suggestion has been adopted in the AA's closing submissions. and that result would be achievable by the exercise of the pylon clause of 11.2 of the service agreement, which he finds is specifically designed to cater for this situation. 2 points there. First, we say that even if one's applying a least burdensome rule, cheapest is not necessarily least burdensome when one looks at the burdens and benefits of various courses of actions in the round. And second, on a strikeout summary judgment application, the judge was in no place to make a finding as to what the clause was specifically designed to cater for. He then goes on to say that paragraph 33, he's assisted by the relevant authorities which he considers binding and can't be distinguished, to conclude that the authorities which identify the least burdensome course of action for the employer in a wrongful dismissal claim involves an assumption of the earliest possible lawful termination. To suggest the employer shouldn't benefit from their wrongdoing by relying upon this clause as a misnomer. And he doesn't accept my suggestions as to why the exercise of the pylon clause would not be the least burdensome options, which he described as a combination of speculative and vaguely defined counterfactual scenarios, which he doesn't consider that the AA should be expected to embark upon. I'm going to seek to persuade you that they're not, neither speculative, I mean they are speculative in the sense that there's a counterfactual to be determined, but that's a legitimate exercise that should have been embarked upon. But the main point I make here is that one needs to treat with some caution the question of the assumption of the earliest possible lawful termination. And I'll show that by reference to the authorities in a moment. That is because the cases that establish that are dealing with would the contract have continued indefinitely or would it have been terminated question. That question, which I accept is not open to me for today's purposes. And I'll seek to illustrate by reference to the cases that earliest possible lawful termination, the cases don't deal with the choice between notice or pylon scenario. And I'll seek to demonstrate that there are good reasons why, when one's looking at what is least burdensome to the employer, simply looking for earliest or cheapest is not a good proxy for least burdensome. Depends on the facts that need to be properly assessed.
So what you want to do is to find a route, alternative route, which maximises your recovery while being able to be passed off as being least burdensome for the other side.
I don't accept the implicit pejorative formulation.
Well, don't treat it pejoratively. But I mean, that if one is trying to encapsulate your interest, that must be it, isn't it?
Well, there's no doubt that Mr. Laddie is right in pointing to the fact that the course of action that I say would have been followed would result in a greater benefit to my client. Otherwise, as he rightly says, we wouldn't be here if I'm saying I should have had less out of it. But that doesn't mean that that answers the question of what the employer or a reasonable employer would have done at the date of dismissal, or which of those would have been least burdensome to it, because there are many factors that one needs to take into account rather than mere cost in the pocket. The problem with the rule, my lord, that says, well, one simply looks at what's earliest and cheapest for the defendant is twofold. First, that gives a considerable benefit to the employer who is the contract breaker, just in and of itself, because they're taken to be, their damages to be assessed on the basis of something that they didn't do and possibly on the facts would never have And second, if one follows the logic of Mr. Laddie's argument of simply pointing to say, well, what turned out to be cheapest in the end, the employer also gets the considerable benefit of hindsight, of being able to work out later on in the course of proceedings at trial what in due course would have turned out to be the most or least burdensome or cheapest option for it, which one can't tell at the time of dismissal which of those it's going to be, or not so readily.
What's wrong with that?
Well, what's wrong with that? But the golden victory tells us that that is the right approach to assessing damages. You don't always do it at the date of breach.
Well, it does say you don't always do the data breach, but
And that's what happened in that case, as you looked at what had in fact happened subsequently.
yes.
But if the least burdensome principle is sound, speaking entirely for myself, I can't see any problem with the fact that you determine what was the least burdensome later.
Well, my lord, I'm afraid I part company with you. I say that does work an injustice for an employee. If one takes the analogy, the example of the employee who's done nothing wrong, gets summarily dismissed, has to have his damages assessed on the basis that he would have been dismissed anyway, even if there was no reason for doing it, has to have it assessed on the basis that a term in the contract which would never have been operated by the employer would have been operated, and in any event has to get it assessed on the basis that only sometime down the line.
But we're dealing with
one
cases
could
in
work out which
contract,
is the
not
cheapest.
tort. I mean, all these arguments would have a completely different resonance if we were talking in court, in tort. But we're dealing in contract, and that's the basis of the rule.
But the basis of the rule is, I say, unprincipled, and that's a matter for. Here, as I accept, I'm arguing about scope of rule and application to the facts. The more full frontal challenge to the application of the rule at all will be a matter for another court. But insofar as there's a rationale for treating the matter in this way by a hard and fast rule that works to the defendant's favour, in my submission, that's to give a degree of certainty in contracts so that the parties know what their bargain is and what their exposure is if it's breached. But if you can't tell what the consequences are going to be until after the event, and you can't tell how the rule is going to apply until after the event, then much of that rationale is undermined. You're left with, one needs to make a factual assessment to determine what would happen. It is difficult to see the principle for applying the rule. Because, my lord, the problem with having a rule at all as to this, as to rather than looking at a question of factual assessment, is one is substituting a rule regardless of the facts. The point is to avoid getting into the facts and finding out what would have happened. So therefore, the presence of the rule assumes that there are going to be cases where damages are assessed on the basis that the employer would have done something that it would never in fact have done.
Can I just clear my mind by trying to articulate what I understand you to be defining as the rule? There's what might be regarded as the more extreme suggestion that Mr. Pratt and others make, that in any case for breach of contract, even if it doesn't have optional or different methods of performance, once it's been broken, damages should be assessed by reference to what the contract breaker would in fact have done, rather than by reference to the minimum contractual obligation.
Yes.
That's not a principle which is open to us to say is wrong, because that's what the majority decided in Laverack and Woods. Leave aside any questions of optional modes of performance. Then there's a different rule, which I think is the one you're addressing, which is that where there are alternative, optional modes of performance, then it's not right that there is any a priori assumption that damages are to be assessed by reference to the contract breaker adopting the least burdensome course. And in those cases, I think you say, this is your first of your 2 points, you look at the counterfactual as to what the employer would actually have done, or the contract breaker would actually have done, if I understood it.
Yes, ma'am.
And that's, it's the, what I would characterise as the least burdensome in optional mode of performance contracts as the rule which you're here challenging.
Yes, ma'am.
Now, just pausing there, are we not equally bound by authority that is the rule? I have in mind, for example, the Withers case, which was a Court of Appeal decision, and a long, long line of cases since Fair and Ewell's, including the House of Lords decision in Bungie and Trade Acts, that if you have a seller who sells a quantity of goods, 5% more or less in seller's option, and the seller's in default, then the damages are to be assessed by reference to the 5% less. That's where you have those 2 optional modes of performance. Why are we not bound by that line of cases in relation to your first point?
Well, because I say that those are not apt to describe the choice that the employer has in this contract, where it's terminated unlawfully operating one mechanism, and the question is, what would have done in respect of termination by operation of one or none of the cases I say address that issue as to which of the permissible modes of termination.
But why is it different in kind? It's a contract which can be performed at the option of the contract breaker in 2 alternative ways. There may be in other cases more than 2, but in this case 2 alternative ways. Contract may be performed by giving a payment in lieu of notice, or it may be performed by giving 12 months notice to expire, so that the employment expires at the end of termination. Those are the 2 optional modes of performance that we're looking at. And your first argument is you don't address whether either of those is least burdensome. You simply look at what would in fact have happened. Why is that not inconsistent with the line of cases I've been identifying?
With the delivery...
5% more or less in seller's option.
Well, because in those cases, the delivering party, if I can use that perhaps an elegant expression, has a positive obligation to deliver. And the question is, if they don't deliver at all, how would they have performed that positive obligation between which of the alternatives? In my submission, it's difficult to make that analogy with a contract that is essentially to employ. The primary bargain between the AA and Mr Mackenzie is that he would be employed and perform the services and earn the money. The question as if they choose to do something that they should not have done, to terminate in breach, as to what they would have done instead, I say isn't analogous to how would the contracting party have performed its positive delivery obligation. But if your lordships are against me on that point, and that I am constrained by authority from my no a priori assumption as to notice or pylon, then first, that's a matter in due course I'll have to seek to raise elsewhere. And second, there remains the question as to how one assesses what the least burdensome means is in a particular case. That's the shape of how I put it.
Thank you.
So the...
Oh, sorry, can I just... Well, that sentence is still in my mind. You say it's a question of how one assesses which is the least burdensome. The less burdensome. It's 2 alternatives. And you say it can only be determined at trial whether the board, properly advised, would have chosen the pylon clause as being less burdensome.
Yes, ma'am.
Well, I think because in answer to my earlier question you said it's an objective, not a subjective test, you'd say the question for trial is whether a reasonable employer would have taken that view. It doesn't involve any inquiry as to what the AA would have done.
Well, but the inquiry has to be in the circumstances that the decision maker was in at the time, with the information available to them,
Of course.
and how they would have acted, how an employer in that situation, with the information available, acting in its interests in good faith, would have acted. But my lord, if I can just illustrate the general proposition that one can't tell from looking at the contract. If we're in the arena of applying a hard and fast rule for the purposes of some certainty as to what the parties' obligations are, one can see, in my Lord Justice Popplewell's example, if one has a contract that says, you can deliver you're obliged to deliver a certain amount, more or less. One can see it's relatively straightforward to work out if the deliverer doesn't do that, what the least burdensome alternative would be. It's going to be less in the vast majority of cases. But here, when one's asking the question, well, what's least burdensome, notice or payment in lieu of notice, you can't ascertain from the contract which will turn out to be the least burdensome. And one can only tell by an assessment of the facts. Because the reason that parties include these various alternative provisions in contracts of employment may be to deal with myriad different situations, and some of which may be more burdensome in some circumstances and more burdensome in other circumstances. So if we're looking for simplicity and certainty, the application of the rule doesn't do it in this type of contract. For example, and I appreciate, my lord, I'm straying in again to my second limb of argument, which is what's least burdensome in this case, but I'm just trying to address the point as I hope as your lordship's concerns arise, I'm dealing with as they come up, so I'm dotting between the two limbs of the argument. Notice or pylon have various different consequences. Let's assume that we're looking to see what the cheapest is, and we're at the date that the decision to terminate is made.
Cheap, I accept your point that the judge was using shorthand. In many cases, it will simply be the cheaper of the two alternatives, but less burdensome to the company or more beneficial to the company is, I think, the correct test. And you don't have to develop the point that it will depend, it will vary from case to case, which is more beneficial to the company. If you take the case of the employee who wants to go and work for a rival, the current employer may say, absolutely, you are not leaving at the moment. You have to serve out your notice. Will maybe a garden leave clause, but in such a case, it is in the company's interest to keep the employee on the books as long as possible. In other cases, I would suggest this one, it is not such a case. So you're right that you can't tell simply by looking at that page of the contract which will be the less burdensome. But isn't it a decision for the employer, the board of the company, to choose which is the less burdensome?
has, insofar as it is, it needs to choose that. That needs to be an assessment as to which it would have done. The effect of the defendant's position is that the employer gets to retrospectively choose what best suits it long after the event, and that's not what. If one was looking at the decision that they would have made, subjectively they would have made, or an objective employer would have made at the time, that's a rather different thing. I mean, just from looking at it from the perspective of what's cheapest, my lord, one can look at it in this way. One of the well-known features of a payment in lieu of notice, as your lordship will be well aware, is that that's then recoverable as a debt, and there's no obligation to, there's no reduction for mitigation from alternative employment in relation to a pylon. So a powerful disincentive, leaving aside your lordship's example, which I absolutely agree with about the question of competition, a powerful disincentive to an employer often to make a pylon is the concern that they're going to pay, let's say, 12 months' money, and the employee is going to walk into a job the next month and largely mitigate their loss, in which case the employer's concern is, well, I'm paying this money for absolutely nothing out of it.
Well, it would be the same if they kept him on garden leave for a year.
So you say it's I'm so sorry I interrupted. Doubly interrupted.
I finished the point.
Well, with respect, my lord, it's not quite, because one has on garden leave, one remains an employee and one has a set of obligations that continue throughout that period compared to being out of employment and the end of those obligations. A former employee who you've just paid a year's worth of money to. So with respect, those are slightly different situations, I would submit. I'm so sorry, my lord.
Well, I'm just looking at the way the claim is formulated on C105.
Yes.
So what you are contending is that it is reasonably arguable, or whatever the strikeout and summary judgment test is, reasonably arguable that the least burdensome, if we apply that approach for the AA, was to pay you 120%, or your salary is 750,000 plus 120% by way of bonus or some proportion of it, plus the other benefits like the car and the driver and so on, quantifying them, rather than the pylon scheme.
Yes.
Which does not bring with it any of the benefits, as I read it. But am I wrong about that?
I'm sorry, forgive me, my lord. I'm afraid I didn't follow that.
The pylon scheme is 12 months' salary.
Yes.
Does that bring with it 12 months of all the benefits as well?
No.
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 That's what I thought.
I misunderstood the question. I'm sorry, my lord. No, it doesn't. And that's
No. Okay.
that's part of the arena of dispute between us as to why I'm claiming those benefits.
Yeah.
Because the defendants say we could have got away without having to pay those benefits by operating the pylon clause.
That's a burden they've avoided.
It is. I accept that as a matter of fact. But my point is, first, the judge struck this claim out on the application of a hard and fast rule that I say he was wrong to do so. And second, when one looks in the circumstances and around as to the range
You say
of
there's a
benefits
factual
and
dispute if you get to stage 2.
Yeah.
There's a factual dispute.
a factual dispute that other issues relating to a managed exit and a more positive resolution of it.
I just wanted to be sure I had not fundamentally misunderstood the opposing positions on 12 months' notice and pylon.
No, you understand it correctly, Mark.
Thank you.
My lord, I'm just pondering whether I'd finished the example sufficiently to your satisfaction of why the pylon may in some circumstances turn out to be more expensive than giving notice.
Oh, certainly in many cases it may be.
So when one then asks the question, what's the least burdensome mode of performance? And if one asks that question at the date of termination, the answer to that is, well, difficult to tell because we don't know what's going to happen. And we won't know until the notice period has expired. And therefore, to work it out requires a factual assessment of what happens over the subsequent period. In which case, why are we applying a rule and what is it if working out the answer to what's least burdensome depends on a factual analysis of what happened in the subsequent 12-month period?
Well, it may not do. The question of whether you're assessing damages at the date of breach or by reference to subsequent events is one governed by the Golden Victory and so on, and the general rule is it's date of breach, but there may be circumstances in which it's later. That will govern whether you look at what would have appeared to the contract breaker at the time of termination, putative termination, to be the most or least burdensome. If you depart from the general rule and assess damages by reference to what's happened since, then you can take into account what you know now as to what would or wouldn't have been the most burdensome. But that question of whether you take breach date or a subsequent date for the assessment of damages, speaking for myself, doesn't seem to me to inform the general principle as to what's least burdensome. It may well be the case that in the circumstances of this case, the breach rule applies, and if the rule is being applied as to what would have been perceived by a reasonable employer, objective, or the AA, subjective, to be the least burdensome approach, you simply look at what they knew at the date of the decision that had to be made, the 1st of August. So speaking for myself, I'm having some difficulty with your argument that it's a consequence of the argument that's put against you that an employer gets the benefit of waiting and seeing what happens subsequently. That, it seems to me, doesn't really address the arguments we're looking at. It's not necessarily the case. That's simply a consequence of whether you apply the breach date rule or not, which has nothing to do with the issue we're concerned with.
Well, I'd make 2 points, if I may, which may or may not assist. But the first is if you assess the damages, if you assess the counterfactual at the breach date, then that is a factual assessment that is quite complicated and needs to be made on, the particularly complicated assessment that needs to be made on the basis of the available evidence. And bearing in mind that the employer is not going to know, a reasonable employer, or this employer, is not going to know what is going to be the cheapest. He's not going to know whether it's going to be cheaper to make a pile-on or cheaper to give notice and then stop paying when the employee gets an alternative, finds an alternative job and is released. If you assess it at the date of trial, retrospectively, then one does have certainty. So Mr. Laddie can say, well, look how things turned out. It would have been cheaper to have made the pile-on. But I say that is an unjust outcome for the employee because it gives the employer far too much leeway in circumstances where it's the wrongdoer to have the benefit of having its damages assessed in those circumstances.
But wait a minute. The contract itself gives the employer the choice. And the contract doesn't say you can, clause 71.2 or whatever it is, it doesn't say you can only activate the pile-on clause for particular reasons. And maybe no reason. And the board of a company using a pile-on clause has to decide whether it perceives that it's in the company's interests to use the pile-on clause. It's true that it may turn out to be a bad idea if the employee takes the money, says thank you very much, and then gets another job at a greater salary. That's a chance that the company take. But so what? I mean, how can the rule be that you can only assess whether the board would have made a decision to use the pile-on clause by reference to what happened later. Doesn't seem to me to make sense.
Well, I don't think I say that the rule has to be that you can only assess it by what. I mean, as a matter of fact, if one's applying a rule that is looking for least burdensome or cheapest, you can only know the answer to that after the event by reference to what happened later. And that's a reason why I say one shouldn't apply the rule. Because there's little point in a rule that can only be, the scope of its application can only be determined after the event.
Well, yes, but that's a point against you, isn't it?
But with respect, I don't think it is. The fundamental problem with the judge's approach is, whether that's a point for this court or the Supreme Court, is that he applied a rule rather than looking at an assessment of what would have happened in all the circumstances. We say that's not properly compensating the employee for his loss flowing from the breach. Because it's a rule, and as a matter of general principle, if it's a rule, then it's going to apply in circumstances that would never have been operated. And that, we say, is an injustice.
Well, that is the fundamental principle established by Laverack and Woods and many other cases, that a contract breaker does not have to pay damages for a failure to do that which he was not obliged to do. And that is the basic principle. Even if, in the counterfactual, he would in fact have done something different from his minimum. That's the principle of the law, which at least at the level that we're sitting is settled.
Yeah, well,
And speaking for myself, appeals to us that works unfairly fall on deaf ears, because simply not open to us to hold that is so. And the points you're making are a consequence of that principle.
When you're seeking to it seems to me, to put wrongful dismissal damages on an entirely different basis from what I was brought up with as an employment lawyer. That I mean, you gave the example of an unjust dismissal for gross misconduct, but it could be any sort of dismissal in contract as opposed to the unfair dismissal jurisdiction. Absolute basic principle is if the contract provides that you can be dismissed on, in this case, 12 months' notice, you can't get an award for lost salary for the rest of your working life on the basis that if the employer had not come to this unjust and wrong decision to get rid of you, you would have continued in the same job indefinitely. You may be able to get damages for unfair dismissal over a longer period than the notice period. You may have a discrimination claim. You may have all sorts of statutory claims in the tribunal. But just looking at old-fashioned law of master and servant in the common law courts, you can never get damages for more than the notice period unless there's something extraordinary in the contract. And maybe that is unjust, but that's how it is.
well, I accept that account of the conventional approach, and I accept, as I did earlier in my submission, that at this level I'm bound by that principle. But I say first, and fight for another appeal, that that shouldn't be the principle. I accept that holds no water here, but I'm making clear what my position is.
Yes.
But second, that proposition doesn't bind in relation to the choice between determining what the choice was between the alternative modes of termination which were not followed, some of which may never have been followed. And those are the...
All right, should we have a look at the case law on that then?
My lord, yes. Well, I was going to start with Laverack itself,
Yes.
if I may. And I have the authorities in 2 files. I think my Lord Justice Popplewell has them in 3 because they're single-sided.
Don't worry, I'll find them. You keep going.
But on any view, Laverack is at in the first volume at tab 5.
Yes.
One sees the facts from the head note. The plaintiff was employed for a fixed term on the second page 279 at the top of the head note. There's a fixed term until 31st of March 1967. So pausing there, this isn't a case about termination of the contract or when it could have been terminated at all. The point in the case is a different one. It's about benefits that would have accrued during the period prior to termination. There's then a description of the bonus scheme at C, against C, in 1965. So that's, sorry, I skipped over the termination. 27th of July 64, there was a dismissal. In 65, there was a revision to the salary structure ending the bonus scheme, and the employer entered into negotiations with employees of a similar grade to the plaintiff, and most of them received an increase in salary. The plaintiff recovers judgment in action for damages for wrongful dismissal, and the damages were assessed on the basis that the claimant would have received a £1,000 increase in salary had he remained in the defendant's employment. So effectively there, wrongful dismissal, question of what damages is the plaintiff entitled to. The master's assessment is that, well, had he remained in employment for the fixed term, nobody arguing about how long he would have been in employment for, he would in fact have received the salary increase, and therefore damages assessed on that basis. Court of Appeal by a majority, Lord Justice Diplock and Lord Justice Buckley in the majority, Lord Denning, Master of the Rolls in the dissenting minority.
Russell, isn't it? Lord Justice Russell, Lord Justice Diplock in the majority.
You're quite right, my lord. Sorry, Lord Justice Buckley features in another one of the cases that I come to in due course. The majority hold that damages for wrongful dismissal couldn't confer on an employee extra benefits which the contract didn't oblige the employer to confer, even though the employee might reasonably have expected the employer to confer them on him in due course. So the obligation was to pay salary of £4,000 a year. Unfortunately for the plaintiff, he had no contractual obligation for the employer to continue the bonus scheme, so he couldn't complain that that had been scrapped, and nor did he have any entitlement to the salary increase. So his damages were assessed on the basis that he isn't entitled to those sums. So this decision turns on the ruling that you don't assess his damages on the basis of an extra contractual benefit that he may in fact have obtained had he remained unemployed, but he had no contractual right to. For your reference, Lord Denning, Master of the Rolls, gives the first judgment. That starts at 285 at E, and he takes a different approach. He rejects the application of the least burdensome performance rule at 288 A to F.
No, he doesn't. He accepts doesn't he? At 288D, he says an attempt was made before us to bring the case within the least burdensome rule. See, Mr. Justice Moore and Cohen-Alexander. But that has no application here. There weren't two ways in which this contract could be performed. So he, like the majority, was accepting that if it had been a contract in which there were two ways in which it could have been performed, then the least burdensome rule in Cohen-Alexander would have been of application. He's not rejecting the least burdensome rule.
No, he was
He's simply saying this isn't a case in which it arises, because this isn't a case in which there are two optional modes of performance.
Yes, my lord, I agree with that. And to the extent that I'd started a sentence that suggested something wider, then I don't depart from
I thought you said that he rejected the least burdensome rule. I'm afraid I regard this as him accepting it. If we're talking about the rule as we've agreed earlier, for the purpose being the one for the purpose of your first submission.
Yeah, well, he's rejecting its application to the circumstances in this case.
But accepting that it is a good principle of law where there are two optional modes of performance.
Well, he's, I mean, he's not really saying anything one way or the other about that, is he, my lord? He's simply saying it's not a rule that applies in this case. Right. He's not, in those circumstances, it didn't call for further analysis on his part. The decision of Lord Justice Diplock starts at the bottom of 291. And the relevant passage is at 293 C to E, which you'll see sidelined. By reference to Abrahams and Riach and Coburn and Alexander. Generally speaking, where there are several ways in which the contract might be performed, the mode is adopted which is the least profitable to the plaintiff and the least burdensome to the defendant. And then at 294B, 3 to F, you'll see the signed line passage. He goes back to Abraham's case, and then at just under D, he says, where there's an anticipatory breach by wrongful repudiation, this can be at best an estimate, whatever the date of the hearing. It involves assuming that what has not occurred and never will occur, has occurred or will occur, i.e. that the defendant has since the breach performed his legal obligations under the contract, and if the estimates made before the contract would otherwise have come to an end, that he will continue to perform his legal obligations thereunder until the due date of the termination. But the assumption to be made is that the defendant has performed or will perform his legal obligations under the contract with the plaintiff and nothing more. What these legal obligations are and what is their value to the plaintiff may depend on the occurrence of events extraneous to the contract itself, and where this is so, the probability of their occurrence is relevant to the estimate. And my lords, I say first that that recognition that events extraneous to the contract may be relevant to the legal obligations and their value to the plaintiff demonstrates that in many cases there needs to be a factual inquiry, even applying the rule, to work out what's the least burdensome. And second, accept a point for a higher challenge, suggests that the rule is rather unprincipled in that it turns out not to be a rule. It turns out to be a rule that does involve an element of factual assessment.
Well, do you extend that criticism to the general rule as Diplock sets it out from B to D? In an action for breach of contract, a defendant is not liable for not doing that which he is not bound to do.
Well, I can't challenge that in this court, my lord, so I have to accept it.
That's part of the ratio of this decision.
Yeah.
And the same thing in different language, the last sentence of that paragraph. If the contract's broken, the assessor must estimate as best he can what the plaintiff would have gained in money or money's worth if the defendant had fulfilled his legal obligations and had done no more.
Yes. But I say that formulation answers the question in Laverack, where the question was the employer obliged either to continue the bonus scheme or to give the salary increase? Answer no. But doesn't answer the question of what the performance of the employer would have been if it couldn't summarily dismiss and was faced with alternative methods of performance. Either would be lawful, but it doesn't preclude an assessment of which it would have done.
I understand your argument in relation to the second and alternative way you put your case, that there's a factual inquiry as to what is less burdensome. But so far as your first point is concerned, i.e. there isn't a less burdensome rule, I understand you say, well, Laverack's not binding on that because this wasn't a case of two optional modes of performance. But we do see that all three members of the court, or, if I'm right, or at least two members of the court, endorsing the principle that where there are optional methods of performance, you do assess damages by reference to the least burdensome. And Lord Justice Ditblock treats that not only as established by Coburn and Alexander, but as indeed having been expressly endorsed by all three members of this court in Abrahams and Raya. So even if not ratio, one's starting to get some pretty powerful dicta.
Yes.
That is the principle that applies where you have optional modes of performance.
And I have to accept that, my lord, and there are plenty of powerful dicta in other cases. In this court, that constrains my scope of argument, and I don't want to, if I'm labouring a point that isn't open to me, I apologise.
And none, so far as I'm aware, to the contrary. There is said to be a different principle where you're not talking about optional modes of performance, but a single mode of performance, which may involve different ways of performing that single mode of performance. But I'm not aware of any dicta going the other way. But please tell me if I'm wrong.
Well,
That there isn't the least burdensome principle applying where you have two optional modes of performance.
no, well, frankly, my lord, there isn't. And if there was, you would have heard about it earlier this morning.
Yes, well,
than now.
Perfectly possible I could have missed it, but thank you.
No. And I don't shirk away from the scale of the challenge as to what is a well-recognised rule that I'm seeking to establish. I'm perhaps on my way to seeking to establish elsewhere. It is unsound in principle, but there's limited. I appreciate that's not a matter for this court today, but I've developed my broader points, firstly so that you can see when one comes to arguments about scope of application and how it applies in particular
So
facts.
when you say it's not a matter for this court, do you say it is open to us to accept your first proposition that there's no less burdensome principle which applies at all where there are two optional modes of performance, and the counterfactual is what would the defendant have done or what would a reasonable contract breaker have done? Or are you really identifying your first argument as one you want to preserve in a higher court?
Primarily the first, but I also say that whilst the principle, as your lordship puts it in general terms, I can't challenge in this court, and I'm identifying my argument for a later date, I say it doesn't answer the specific question in this case as to the approach to the choice between.
I understand that. You've got your second point, that if there is a less burdensome principle, that's a factual inquiry, and in this case, that's a matter for trial. I understand that.
Yes.
But your initial point is there isn't a less burdensome principle in a case like this. And I just wanted to be clear whether you were saying that is something which it is open to us to decide, or whether you were recognising that it's not open to this court to decide that, and you simply say that ought to be the position, and you reserve the right to advance that argument in a higher court.
Well, it's the latter in relation to the general principle, but I do say that in this type of contract where one is looking at the circumstances where one's choosing between the counterfactual of exercise of pylon or notice. First, the general proposition, I say, the general rule doesn't actually help answer that question. And second, the cases don't directly address it. But I appreciate there may not be a great distinction between that formulation of my first point and my second, more fact-based point.
So have I understood it correctly? You accept as a general principle, so far as we're concerned, so far as authority by which we are bound is concerned, as a general principle that where there are two optional modes of performance, damages are to be calculated by reference to the least burdensome option for the defendant. But it's part of your first point that that is a principle which isn't applicable to the two options, or the two options we're considering in this contract of employment. Is that your first point?
Yes.
And forgive me because you have touched on this already, but I'm afraid I don't have a very sound grasp on why you say that the two options in this case are outside that principle. Could you just articulate it again for me?
My lord, yes. Well, first point, which doesn't directly address your question, but I reiterate it, that in terms of binding authority, none of the cases are a specific application of the principle to that particular type of contractual choice. Second,
I don't quite understand that. There are options. In the language you've been speaking, the pylon or 12 months notice are options. Where do you go from there? As a matter of principle, you say that Laverack wasn't a case of optional performance, but you accept that there are plenty of powerful dicta, which I think is, I think the result of your discussion with my lord a moment ago is that you accept that for all realistic purposes, we're bound when there's a case of optional performance. You accept that there are two options here. Speaking entirely for myself, I am not understanding what it is about these particular options that you say takes it outside the principle, if the principle is established.
well, on the one hand, one has the cases that look at the positive obligations that the contract breaker had. They've got an obligation to do something, and the question is, what are their options as to how to do it? So it might be a contract to deliver a quantity or a range of quantities, or to do something in the place. But the positive obligations under this contract are to employ and to give work and to pay. I say it's a different type of question when one's looking at the question of termination of that relationship.
But the obligation may be to employ, but it's subject to the two optional modes of termination, which we've been discussing. So, and unless you simply adopt the Pratt argument and extend it to say, well, because they could have, if if they hadn't, they might have gone on and given him every single benefit under the sun. Therefore, that must be there should be a factual inquiry about what is lost. Unless you ask us to accept that, which, speaking for myself, is not an attractive proposition at the moment in the current state of authority, I just do not understand. It doesn't matter whether they're negative obligations or positive obligations. They've got two optional modes of bringing this contract to an end. Why isn't it within the principle? Assuming the principle is as stated at 294 B to C.
294
B to C, which I think we accepted as ratio. I may be being very slow about this, but at the moment I can't do it.
Just going to take a moment, if I may, my lord, to
Yeah. Yes, do.
the most helpful way to answer.
For my benefit, please.
No, I didn't mean it in that way.
No.
It's certainly for my
I'm not being
benefit.
facetious, but it seems to me that we've got to the nub of application 1, thanks to my lord's discussion with you over the last 5 minutes. And at the moment, I don't see how you, and I do not mean this pejoratively, but let me use completely neutral, I do not see how you escape from the principle.
Well, my lord, my answer to the question leads in to the second strand of my argument. How do you, I suppose, I'm just trying to helpfully narrow down what I'd say. I'm just thinking carefully. If one looks at the question, if the defendant, and I'm at 294D in that passage, if the defendant had fulfilled his legal obligations and had done no more, well, if one looks at a contract of employment that admits of, well, I'll take a step back. To go to the example I gave to my Lord Justice Popplewell, if one's got a contract that permits a deliverer to deliver different amounts of things, one can answer that question readily, and one can see that the question of asking oneself what are the legal obligations and no more than those legal obligations is both useful and easy to answer. But where you've got a contract where the positive obligations are to employ, then asking one to look at if one has a wrongful termination agreement, if one then answers oneself the question, well, what did the employer need to do to fulfill its legal obligations but do no more, in the circumstances where it didn't do either of those things? In my submission, the principle doesn't answer that question, right? Because of the very different circumstances in which the different termination mechanisms might have operated.
Well,
Sorry, I've blown you off course again.
my lord says, I'll repeat the stage whisper, because you need to grapple with it, Mr. Mansfield. My lord said he didn't understand the answer, and nor do I, I'm afraid.
Why can't you treat the two optional modes of termination as being equivalent to the plus or minus 5%? There's an obligation to deliver plus or minus 5%. There's an obligation to employ plus or minus two optional ways of terminating. You say they've terminated unlawfully, they're a contract breaker. The response comes back, yes, but there are optional ways of performance, which include termination, pylon, termination 12 months. You're trying to drive a wedge between positive obligations and negative obligations, I think. But at the moment, I have to say, I can't see a difference of principle if one looks at how it's been formulated overall, and I'm not aware of any authority which supports your suggestion that this is a special case.
Well, the only authority I'm aware of that touches on that difference between positive and negative obligations is the Jones and Rico case, which is about breach of confidentiality undertaken and negative obligations of confidentiality, where there was a rejection in Miss Justice Roth's decision on summary judgment of the...
Yes, a negative obligation not to publish the confidential information.
Yeah.
Okay.
But my lord, I will, in due course over this short adjournment, if I may, reflect upon whether there's anything I can put for you that assists you further on that. I accept that some of my points have strayed into my second string. My second string's the wrong way of putting it. My second argument about how does one work out what the least burdensome performance argument is.
Well, that's conceptually much easier.
Yeah.
All right.
As
Well,
an
perhaps,
argument.
If you're against me on...
Perhaps we've done point one to death, and so far as we can, subject to any inspiration you get, or Mr. Jackson telling you that there's an obvious answer you should have given. Let's go on to point two. Now, are you saying that there's any of the subsequent authorities, particularly appellate authorities, throw doubt on the applicability of Laverack to a case of this kind?
Well, there are, I say, they don't really address its applicability to a case of this kind. But I've accepted, as I accepted to my Lord, Lord Justice Popplewell, the dicta in many cases cite the application of the principle without much challenge to it. Many of the cases are drawing a distinction as to the scope of the situation where the rule applies and the situation where the rule doesn't apply. A case that we rely on is the Durham Tees Valley case.
Yes. Well, perhaps we should look at it. You cite from both Lord Justice Patton and Lord Justice Toulson, and what do you say? What is the ratio of the Durham Airport case?
If you give me a moment, I'm just looking at
tab 23.
Sorry, I thought I was in the wrong one. I have it. It's at tab 23. The ratio is best seen in my submission, summarised in the head note at 3 on page 732.
Yes.
Where a contract imposed a single obligation rather than alternative obligations and gave a party discretion on how to perform that obligation, the assessment of damages for the breach of the contract shouldn't be limited strictly to what was the minimum level of performance required by the contract. The court had to conduct a factual inquiry as to how the contract would have been performed had it not been repudiated. Its performance was the only counterfactual assumption in the exercise. On the basis of that premise, the court has to look at the relevant economic and other surrounding circumstances to decide on the level of performance the defendant would have adopted. So the distinction that is drawn is between single obligation with discretion as to how to perform on the one hand, this case, and alternative mode of performance cases on the other hand. And I say that is a significant exception to the scope of application of the rule as we're calling it, and is really a distinction without a difference. It's an unprincipled distinction. And your lordships may feel this is an argument to preserve for further appeal than for now, that it is difficult in principle to see why in a single obligation with discretion as to how to perform, one undertakes a factual inquiry, whereas in a contract that delineates options rather than discretion, one is taken as to applying the minimum.
Well, speaking for myself, I think you may be right that it would be odd if there were entirely different regimes, but I wonder whether there are entirely different regimes. If you look at Lord Justice Toulson at 79, which is, that's really where the head note drafters got their material from. Couldn't it be that there's a single rule that you assess damages for breach of contract on the basis that the contract breaker would have acted in the way which was most beneficial or least burdensome to him, but with the proviso that he would not cut off his nose to spite his face. Example, take as an example, it's not actually how they put it, but the facts of Abrahams and Rayach, the contract is for the defendants to publish the plaintiff's book, and there would be a royalty of 4p on each copy. Well, of course it would be wrong to assess the contract. The contract made no provision for minimum numbers. Well, of course nobody would do a print run of 10 or 50 copies just to spite the plaintiff because he would only get 4p a copy. The Court of Appeal had to take some view of what a reasonable figure would have been. In Bold and Brough Nicholson, the employers could, as a matter of contract, have wound up the entire pension scheme, but it's absurd to say they would have done that just to spite the plaintiff. One can think of other examples, no doubt, but where the defaulting party has a single obligation, then you can assume, as in the sale of goods case, that the defendant would have chosen the least burdensome way of carrying it out, and if there are alternatives, you can assume that the defendant would choose the less or least burdensome way of carrying it out. Why should the obligation be different?
But with respect, my lord, that's not how Lord Justice Patten or Lord Justice Toulson addressed the issue. In my submission, they didn't decide the case on the basis, well, this is a least burdensome mode of performance case, but with the assumption that no one's cutting off their nose to spite their face, to use that expression from Laverick. They both determined that there needed to be a counterfactual assessment rather than the application of a rule. There needed to be a counterfactual assessment of what would have happened but for the breach, and that's a somewhat different approach in my view.
Why is it different? I'm looking at Lord Justice Toulson, paragraph 79. What we can go to Lord Justice Patten in a moment, but let's start with Toulson. Is there anything in 79 which actually helps you?
Well, yes, my lord. What Lord Justice Toulson is referring to is the exercise of the court has to look at the relevant economic and other surrounding circumstances to decide on the level of performance which the defendant would have adopted. Judge conducting the assessment must assume the defendant wouldn't have acted outside the terms of the contract, would have performed it in its own interest, having regard to the relevant factors prevailing at the time. And then your court's required not to make assumptions which would have acted uncommercially. That exercise is, with respect, totally different to the application of a rule that says this term is the least burdensome one, and therefore that's the one that we're to assume that the employer would have adopted. Because in this case, the judge precluded any of that assessment by simply saying, well, cheapest and earliest is least burdensome. That's the pile-on clause. No inquiry to be conducted. It applies a hard rule.
I know it's not quite what you said, and I know that there appears to be continuing debate about whether paragraph 79 is Lord Justice Toulson or Lord Justice Patten. Which I think it may be Lord Justice Patten with Lord Justice Toulson starting at 81.
You're absolutely right.
Well, quite right.
Whichever and howsoever expressed. Speaking for myself, I would find that paragraph clearer if just below C, the first line, the first word, instead of being would have been performed, it was should have been performed. Because it seems to me that what the court was actually doing there was saying, if you read this contract in accordance with normal principles of construction, you have what would in effect be an implied term, which is that proper performance of the contract is not achieved by producing one book. And the court below took a figure which it assessed as being a reasonable and rational performance of the somewhat nebulous contract that they had, because the contract didn't specify. If you then look at it and you look a little bit further down, the judge conducting the exercise must assume that the defendant would not have acted outside the terms of the contract and in commercial interest. It looks, to my way of thinking, and maybe you will tell me that this is not open to me because of what the judges actually said, but to my way of thinking, what they are doing is working out what the obligation was in relation to print run and saying that can be read obviously subject to reasonable commercial interests but not spiting the face. So it's very, to my way of thinking, it's very, very, very close, if not actually effectively the same as what we've been talking about already. That may be wishful thinking, trying to find consistency where there isn't any.
Well, my lord, I don't think the court proceeded on the basis of identifying an implied term that answered the question. It approached it as a matter of application of a rule to the assessment of damages, and one can see that from earlier in Lord Justice Patten's judgments, and I apologise for my slip in misattributing the passage. Lord Justice Patten, of whose, that's at the end of his judgment, the beginning of the section on damages begins at 62.
Yes.
And having dealt with a question of construction and a question of an argument about lack of certainty of terms, we see at 62, he then comes to start this section, which is about the assumptions to be made on assessing of damages. It says the issue that's been raised as to whether the court's required to assume that the party in breach would not have operated above the minimum level of performance required under the contract, although not decisive of the appeal, remains relevant to the computation of damages of assessment. So he's certainly dealing with it as a question of assessment of damages. And he sets out at 63 and some 64 the established principles as to the ordinary basis of inquiry as to damages. breach of contract. And if one goes over to 753, he deals with Lavrak. And then at C, just below C, he says, the question in cases of this kind is whether the argument or principle that a claimant should not receive damages for something the defendant was not, strictly speaking, required to do, should displace or limit the court's factual inquiry as to what in the circumstances, bar the repudiation, the defendant would in fact have done. And then he goes on to say the question of which is the correct test to apply to this legal hypothesis has been considered in a series of cases. He goes on to deal with the cases. So the question he's addressing is about whether or not a rule or principle displaces factual inquiry. He's not dealing with it as a question of the solution to the problem was not a question of implication of terms. And if while I'm here I might follow through the judgment. He deals first of all with the Abraham's case. And at 69, he says there was clearly a consensus between the members of the court that in relation to alternative methods of performance, the claimant will be unable to rely upon the defendant performing the contract in the more onerous of the two or more ways permitted. But that wasn't the type of contract under consideration in Abraham's case, and it's not the type of contract that we have to deal with in this case. Where there's only a single obligation to be performed, it's clear that the majority view was that an assessment of damages should not, as a matter of law, be limited to strictly what was the maximum level of performance permitted under the contract, but should extend to a calculation of how the contract would have been performed at the relevant time had it not been repudiated. This will take into account the likely profitability of the contract and any other relevant facts that would have influenced the method of performance. So
that's an interesting observation to my way of thinking, in the light of the end of paragraph 63, which says the inquiry is therefore directed to what the party in the contract in breach is taken to have done had he in fact performed the contract. In all cases of repudiation and possibly even breach, there will be a counterfactual assessment which will involve the court and stipulate the manner of the performance which is to be assumed. So that I take as being neutral. But then in 66, the second line of the citation, the question is what will satisfy the obligation. And at the top of the next page, the citation from Lord Justice Scruton, I think the appellants were bound to make such a publication as could be considered reasonable. So that's talking about the, sort of the underlying obligation, to my way of thinking. But I agree with you, 69 doesn't go down that line.
Well, indeed. He then goes on to deal with Lavrak's case at 70, which of course we've already looked at this morning. End of the page at 71. It's important, I think, to read the references to the defendant being assumed to have fulfilled his legal obligations and nothing more in the context of what the court had to decide in that case. The issue to which those observations are directed was whether the damages awarded for the wrongful repudiation of the contract should include compensation for the loss of bonuses which the employer was never under any form of contractual obligation to pay. Lord Justice Diplock wasn't, I think, referring to the questions decided in Abraham's, which was how to assess damages in relation to the benefits which were undoubtedly contractual. And then he goes on to distinguish the discretionary bonus case of Hawkulack and Cantor Fitzgerald at 72 onwards. Before recording at 74, these cases don't really resolve the difference of opinion which existed between the members of the court in Abraham's case. by which he means a difference of opinion between, on the one hand, Lord Justice Scrutton, and on the other hand, Lord Justice Atkin and Lord Justice Banks. And then he comes to his resolution of the issue, which is about the single obligation issue at 79. Lord Justice Toulson agrees with Lord Justice Patton, and that's in the middle of page 759. He deals first of all with the construction and uncertainty points before coming to issue 3 on page 761. How should the court approach the question of damages for breach of the obligation? Over at 95, he says the cases show the question of how damages should be assessed for repudiatory breach of contract, which allows a measure of choice to the party in breach, the defendant, may be difficult. And by reference to Lord Justice Mustle in a case called Paula Lee, the principles really have to be considered, but the less clear than may be thought. It may be added that it's not easy to reconcile all the dicta in the various cases. And he then sets out the cardinal principle of assessment. So the innocent party is entitled to be put in the same position as would have been if the defendant had not broken the contract. That requires a careful analysis of the contract. Subsidiary general rules have been developed for measuring damages in different types of case, although there may be a need for caution to see that they're not applied mechanistically in particular situations where to do so would defeat the cardinal principle. And then he sets out, he says, as the case law shows, there's a wide range of possible permutations which may affect the right way to assess the damages. And then he sets out 4 cases, although he notes that not every case falls neatly into them, and you see those set out there. And here, I absolutely advance the point that one needs to be cautious to see that the principles are not applied mechanistically in a way that defeats the cardinal principle in a particular case.
But he then identifies the first of those cases as one in which the contract requires the defendant to do X or Y, and goes on at 97 to say in that kind of case the answer is straightforward. It's the rule in Robinson and Robinson, least burdensome mode of performance.
But again, I mean, this is the point that I struggle to draw a distinction to the satisfaction of my Lord Justice Stuart-Smith a moment ago. It's a curious way to describe a contract of employment as a contract that requires the employer to do X or Y. The obligation is to employ him. Nobody thinks of their contract of employment as what is the obligation in your contract of employment. Well, nobody starts with the termination provisions in that case. What about your new job? I've got a 12-month pilot.
That's because the principle which you accept, that the counterfactual is, generally speaking, the earliest date of termination, or at least a termination, rather than indefinite employment, is, as Lord Justice Buckley explained in Gunton, the very rule itself, that it would be more burdensome to keep what is assumed to be more burdensome, to keep the employee on indefinitely, than it would be to bring the contract to an end at the earliest time at which the employer can do so. That's an application of the principle, not some separate element of it. And that's why one's looking at when would have been the least burdensome, what would have been the least burdensome mode of terminating, because we are looking at termination as the least burdensome end result.
Well, one has to look at termination as the end result, and I accept that in this court I'm constrained by authority, whether that is a result of an assessment of what termination being least burdensome, or whether it's just a function of what the courts have decided the permissible interplay is between contractual and unfair dismissal rights is a separate question, I think. don't think it necessarily follows that the courts are saying that the assumption of termination derives from the least burdensome principle. But my lords, I say, and I preserve my position on this for further appeal, that the distinction that is drawn between the contract requiring the defendant to do X or Y on the one hand and a single obligation with different methods of performance is an unprincipled one and strikes at a flaw in the heart of the rule. But for today's purposes, I'm constrained perhaps to my narrower point, which is that when looking at what's least burdensome between X and Y, that's an exercise that does require a counterfactual and an examination on the evidence.
Right. Now, is there anything else you'd like to show us in the authorities? You will have a short adjournment to think in particular about whether you have anything to say to deal with the ball that Lord Justice Popplewell bowled at you concerning the resignation from directorships. But that apart, are there any other cases you would wish to show us?
Can I deal with Smith and Trafford, which is a case relied upon by my learned friend below and relied upon by the judge in his decision? And that's at tab 28, which...
Second bundle.
Second bundle. I have it in first.
Confession time. I confess I have not looked at this, so if you could introduce it.
Nor have I, but I think I've seen it referred to in discussion and argument.
But I haven't read it.
Forgive me, my lords, I have another exploded file, so I'm just putting that back together. So, this is a case, Marl, if we start from the head notes, this is a case about a housing manager who had made Facebook postings that his employer disapproved of, and it regarded as being a matter of misconduct. As a result of that misconduct, using a right under the contract, the employer demoted the employee as a disciplinary sanction. So he was demoted and he had a reduction in pay. He carried on working in that demoted role at lower pay under protest and then sued for the amount for damages being the difference between the amount that he was in fact being paid and the difference and the amount that he was due to be paid prior to the demotion. Much of the case, much of the head note, turns on the question as to whether or not the claimant's Facebook postings amounted to misconduct or not. We don't need to concern ourselves with that for today's purposes. Mr. Justice Briggs, as he then was, decided that the postings didn't amount to misconduct, and so therefore the employer was in breach of contract by demoting and reducing pay. But when it came to damages, the analysis was less favourable to the claimant, and one sees in the head note, it's a long head note, but the only passage relevant to damages is at 2, which is on page 88. Mr. Smith's purported demotion in breach of his contract of employment amounted to a wrongful dismissal. He'd entered into a new contract with the trust in substitution for the original contract and insensible mitigation of his loss. Damages for wrongful dismissal are limited to the financial loss during the contractual notice period. Accordingly, the measure of damages was the very small difference between his salary under the first contract and the amount actually paid to him during the 12 weeks following his assumption of the new but reduced role. So even though nobody treated him as being dismissed at the time, he was found in fact to have been dismissed in breach of contract and re-engaged, and his damages were limited to the 12-week notice period rather than the longer period of time. There was an attempt to argue on the claimant's behalf that the Durham Tees Valley case, referred to here as the BMI Baby case, changed the landscape in relation to this. The section in relation to damages starts at paragraph 87, which you'll find on page 96. First of all, 87 through to 94, sorry, to 93 deals with the question of whether or not the demotion amounted to a wrongful dismissal. Then one sees that Mr Tomlinson, for the claimant, submitted that the, 95, therefore necessary to consider whether the previously settled law, namely that damages for wrongful dismissal are limited to financial loss during the contractual notice period, has been undermined by recent case law. Pausing there, as I indicated at the opening of these submissions, I'm not saying that damages go beyond the notice period. My submissions are focused on the distinction between the pylon and the notice point. There's reference, an argument based upon Durham and Tees Valley, and Miss Justice Briggs says at 100, there are, I think, two reasons why it should be concluded that no inroad has in fact been made. The first is that BMI Baby was a case about a contract specifying a single method of performance but giving the party in breach discretion as to how to perform it. That it was this type of contract was important to the outcome. So, I mean, I've made my submissions on the impact of BMI Baby and what that tells us previously. So this is an application of his understanding of that case. By contrast, an employment contract terminable on notice is not a contract for the performance of a single obligation for a specified period, but rather a contract giving the employer a free choice as to its duration, subject only to giving the requisite contractual notice period of notice slipped over myself. Subject only to giving the requisite contractual period of notice of termination. Employment beyond the earliest contractual termination date is not something to which the employee has a contractual right. Now, the point I want to make, that is important not to read too much into that in my submission. This is a case where the choices were notice or continuation of employment, and as I've indicated, I'm constrained in this court to say I accept that one proceeds on the basis that the contract would have come to an end. But the court wasn't addressing the question of whether it comes to an end by notice or pylon, because it didn't arise. And then the judge goes on to deal with the impact on the proposed counterfactual of assumptions about avoiding unfair dismissal, which he thought it inappropriate to get into. And at 104, he says, if a fear of unfair dismissal is excluded from the counterfactual analysis, I can't envisage any reason why the trust, concerned to comply purely with its contract with Mr Smith, would have done otherwise than give him 12 weeks notice and then offer him a more junior but different role. So, in fact, having looked at the principle, he then goes on to look at the counterfactual and make a decision based on
Could you read the next line, please?
This is what the trust wished to do, not only in order to give effect to its misguided perception that Mr Smith had conducted himself in a manner contrary to the Code of Conduct and the Equal Opportunities Policy, but also to send out a message to all of its employees not to use Facebook in the manner adopted by Mr Smith distance itself from any risk of association with Mr Smith's views about gay marriage in church. Unless constrained by the employment legislation to do otherwise, I conclude that even applying the counterfactual analysis developed in the BMI baby case, the Trust would nevertheless in fact have done what it did, but upon 12 weeks' notice. So the conclusion is that Mr Smith is only entitled to the very small difference between his contractual salary and the amount I'm actually paid to him, although 106, Ms Justice Briggs goes on to say this: I must admit to real disquiet about the financial outcome of this case. Mr Smith was taken to task for doing nothing wrong, suspended and subjected to a disciplinary procedure which wrongfully found him guilty of gross misconduct, and then demoted to a non-managerial post with an eventual 40% reduction in salary. The breach of contract which the Trust thereby committed was serious and repudiatory. The conclusion that his damages are limited to less than £100 leaves the uncomfortable feeling that justice has not been done to him in the circumstances. And that's what... He's applied a rule, but it's an illustration, as the points that I made earlier, that it is a rule that is... I mean, I've said it's unprincipled, but it can work. And we say in this case, works in injustice.
Well, of course it can. But if poor Mr Smith had issued his employment tribunal case in time, it might have been a massive claim. It's a strange case because the fact that he didn't meant that all he got was £100.
Well, my lord, yes, but that is, I mean, that's true, except he could have, clearly the court indicated he could have issued a claim for unfair dismissal, but as your lordships will know, in many cases, that is scant comfort to those who are employed above the statutory cap, and it doesn't avoid the necessity to look at applying the cardinal principles of assessment of damages to compensate the parties for putting them in the position they would have been if they'd not been breached, in my submission. My lord, that's what I wanted to say about that case. May I take the short adjournment to consider not only parked answers to your questions, but also what else I need to address this afternoon?
All right. We'll resume at 5 to 2 then.
Right.
How you doing?